Welcome back to this course on copyright and related rights law. In this session and the following few sessions, we are going to understand what amounts to infringement of copyright under the Indian Copyright Act, and we will also understand how the courts are assessing infringement. Let us look to the meaning of infringement. Infringement simply refers to the action of breaking the terms of a law, an agreement, and in effect, an infringement can be used synonymously with violation. Let us then see what Section 51 is saying about the kind of acts which will amount to violation of copyright. Section 51, Clause A, Subclause 1 is saying, copyright in a work shall be deemed to be infringed when any person, without a license granted by the owner of the copyright or the registrar of copyrights under this Act, or in contravention of the conditions of a license so granted, or of any condition imposed by a competent authority under this Act, does anything, the exclusive right to do which is by this Act conferred upon the owner of the copyright. Let us first recall what are the exclusive rights that would be violated under Section 51. This is in reference to Section 14, which we had understood as a reference to a bundle of rights connected to subject matters. Therefore, for a particular subject matter like a literary work, an act of reproduction would amount to violation of copyright if it is not authorized by the copyright holder. Let us also recall who is the owner of a work. The owner of a work, as we had understood, is ordinarily the author, but there are certain circumstances that have been provided within Section 17 of the Indian Copyright Act in which the first owner need not be the author of the work. An example that we had considered was that of contract of service, wherein there is an assignment by the author to another person. There is transfer of ownership, and this ownership, mind you, need not be over the entire copyright, could only be with respect to part of such copyright. How can competent authority authorize? We had discussed with relation to compulsory licensing, for example, that a license could be granted on conditions that are determined by the commercial court and based upon which the registrar will issue a license. Therefore, wherever there is a clear authorization with respect to what copyright can be used, in what duration and what territory, for example, if there is a violation of these conditions, then it will amount to infringement. When we then look at 51A, subclause 2, we see that there is a different facet of what amounts to copyright violation that is covered. It says, copyright in a work shall be deemed to be infringed. It says the same thing what is said in the earlier provision, and then proceeds to say, permits for profit any place to be used for the communication of the work to the public, where such communication constitutes an infringement of the copyright in the work unless he was not aware and had no reasonable ground for believing that such communication to the public would be an infringement of copyright. This provision tells us that a person has allowed his premises to be used for communication of the work, wherein the person whose premises were being used was not aware that such communication was in fact infringing in nature. In what situations can such an act occur? Imagine a concert. In a concert, the permission to use the premises may be given to, for example, a band. But say, among the songs that are communicated by such band, one particular song was unauthorized, belonged to a certain copyright holder, and therefore was unauthorized. Where there is a clear violation of copyright, as far as the owner of the premises is concerned, it might be that he was completely unaware. And what Section 51, Clause A, Subclause 2 is saying is that even though such a place was provided for the purpose of profit, because the person was unaware, had no knowledge, it would not be possible for there to be an infringing action against such individual. Another interesting consideration that we must make is that under this provision, is any place restricted to physical platforms? Could it also not include digital platforms? For example, many of us use YouTube. Isn't YouTube a platform which is permitting the usage of works which are uploaded onto YouTube for the purpose of profit? And therefore, can we not say that something like YouTube can also be covered within 51 Clause A, Subclause 2? In which case, if there is infringing activity on YouTube's platform, would YouTube also be considered as an infringer, or can YouTube say that it had no knowledge of such infringing activity because there is millions of users who are using YouTube, they are uploading infringing activity, and even if the technological development is allowing YouTube to flag many of these videos as infringing, if in fact some do get uploaded and they do not have actual knowledge of such uploads, then would YouTube be not held as an infringing entity under 51 Clause A, Subclause 2? This interesting question was considered by the Delhi High Court in the case of MySpace versus Supercassette Industries. Let us see what the court is saying. Section 51, Clause A, Subclause 2, in the case of internet intermediaries, contemplates actual knowledge and not general awareness. It contains in the second part an exception, that is, of lack of knowledge or reasonable belief, where a party is unaware and had no reasonable ground for believing that the works so communicated are infringing works, then the first part casting liability would be inapplicable. What are we understanding? That, in fact, platforms such as YouTube can take advantage of such an exception. And the court explains that this is because we cannot be equating situations that occur in the real world as opposed to how it is occurring in the digital world, where millions of uploads could happen on such a platform. It would be impossible with the technology that is presently available to identify each and every violation. It would be possible for platforms to flag possible violations, but this could possibly not be done with respect to all works. It is then pertinent that fixation of liability with respect to such platforms be limited to only those circumstances where actual knowledge can be proved. And how will actual knowledge arise? Where it has been brought to their notice, where the right holder has brought the infringing activity on the platform to the notice of such platform, then they will not be able to take recourse to the exception provided under Section 51, Clause A, Subclause 2. As the court says, knowledge has a definite connotation, that is, a consciousness or awareness and not mere possibility or suspicion of something likely. Before looking to Section 51, Clause B, let us understand what infringing copy means. Infringing copy has been defined under Section 2, Clause M of the Indian Copyright Act, in which it is stated that in relation to a literary, dramatic, musical, or artistic work, a reproduction thereof otherwise than in the form of a cinematograph film. Meaning that any reproduction which isn't a visual recording, what a cinematograph film is, any such form of expression would be considered as an infringing copy. But wouldn't a visual recording of such a work also be an infringing copy? This clarification we find under Section 51, wherein the explanation reads that for the purposes of this section, the reproduction of a literary, dramatic, musical, or artistic work in the form of a cinematograph film shall be deemed to be an infringing copy. The provision further reads that in relation to a cinematograph film, a copy of the film made on any medium by any means, in relation to a sound recording, any other recording embodying the same sound recording made by any means, in relation to a program or performance in which such a broadcast, reproduction right or a performer's right subsists under the provisions of this Act, the sound recording or cinematograph film of such program or performance, if such reproduction, copy, or sound recording is made or imported in contravention of the provisions of this Act. What Section 2 Clause M is saying is that when we are considering the specific unit, which is an alleged infringement, in what way will we categorize that unit as an infringing copy? What is it an infringing copy of? And Section 2M, for example, says that if there is a sound recording of a performer singing, then such a sound recording is to be considered as an infringing copy of the performer's right. That is how we need to be looking at infringing copies. Another example that we can consider is that supposing the alleged infringing unit is a visual recording, then it is a cinematograph film which is an infringing copy of another cinematograph film. Let us then see now what Section 51 Clause B is saying. Section 51 Clause B talks about certain situations in which there is dealing in infringing copies. This kind of infringement is also referred to as secondary infringement, because as you would note, the copy is being called as infringing because infringement has occurred. Let us then see what is 51 Clause B subclause 1. It says, when any person makes for sale or hire, or sells or lets for hire, or by way of trade displays or offers for sale or hire any infringing copies of the work. So, where infringing copies are available to such person, and such person is engaging in its sale, or he is engaging in hiring of such infringing copies, he is offering it for sale, then in such situations, such a person is considered to be infringing the copyright. Similarly, 51 Clause B subclause 2 talks about how distribution of infringing copies is also something that will be covered within an infringing act. It says, when any person distributes either for the purpose of trade or to such an extent as to affect prejudicially the owner of the copyright any infringing copies of the work. We can clearly make a distinction between the first provision and the second provision. The first one talks about sale or hire. The second provision talks about distribution. Clause 3 talks about exhibition, where infringing copies are exhibited to the public, then such exhibition or the act of exhibiting would be considered as infringement as well. Imagine a gallery where infringing copies are being exhibited. And clause 4, which says, when any person imports into India any infringing copies of the work. You would recall that this is a discussion that we've had earlier when we discussed parallel importation. In that line, we had also discussed how there is a proviso within Section 51 which permits the import of one copy of any work for the private and domestic use of the importer. With this, I hope you have understood what Section 51 states infringement is. But when an infringement action comes before the court, does the court restrict itself to this very aspect of what is mentioned within 51, or does it bring in its own sense of inquiry, assessment, and analysis? This is something which we will take forward in our next discussion. Thank you for joining me. See you all in the next discussion. Thank you.